Hello, everyone, and welcome. I'm Dr. Felicia Caponigri, Program Director of Notre Dame Law School's Program on Intellectual Property and Technology Law. I'm very happy that our program has partnered with the Hesburgh Library, and each year we celebrate Fair Use Week, supporting an interdisciplinary conversation about what fair use is, the importance of it for our academic community. This year, we're spotlighting text and data mining in digital humanities, and we're so proud to welcome Professor Pam Samuelson and to spotlight the great work in the digital humanities that's being done on our very campus. So without further ado, I'll pass the word to my colleague, Monica Moore, the Scholarly Communications Librarian at the Hesburgh Library.
Wonderful. Thank you. Thank you, Felicia. I just want to echo my enthusiasm for this program and to talk about what a great collaboration it has been between Hesburgh Libraries and the law school. I just think it's such a great example of interested parties coming together to discuss common problems and solutions. And it's especially gratifying in my role as a scholarly communication librarian to see that convergence. I really hope it continues. So one thing I'd like to stress is how much the Hesburgh Libraries exist to connect people to knowledge. In fact, that's actually our mission statement. And traditionally, we've done that through collection development and through acquisition models, but we're increasingly investing in expertise and technologies to help our users create new knowledge. And I think the Navari Family Center for Digital Scholarship here in the library is a great example of our commitment to supporting emerging forms of digital scholarship. And that certainly includes text and data mining. So we're delighted to be able to talk about that topic today and have such a great panel of experts, including our own interim director of the CDS, Natalie Meyers. So I'll hand it over to Professor McKenna, who can get us started. Thank you.
Great, thank you. Hi, everyone. I'm really pleased to have the ability tonight to introduce our keynote speaker, Pam Samuelson. Professor Samuelson is the Richard M. Sherman Distinguished Professor of Law and Information at the University of California, Berkeley, where she's also a director of the internationally renowned Berkeley Center for Law and Technology. Professor Samuelson is one of the world's leading intellectual property experts with a particular focus on digital copyright law, cyber law, and information policy. Since 1996, oops, I lost my notes there. Sorry. Oh. Sorry, Pam, I lost my notes introducing you. Okay, sorry about that. Since 1996, Professor Samuelson has had a joint appointment at the Berkeley Law School and the UC Berkeley School of Information. Professor Samuelson is is co-founder and chair of the board at the Authors Alliance, a nonprofit organization that promotes the public interest in access to knowledge. She also serves on the board of directors of the Electronic Frontier Foundation, as well as the advisory boards for the Electronic Privacy Information Center, the Center for Democracy and Technology, Public Knowledge, and the Berkeley Center for New Media. She's got an incredibly extensive publication record. If I read it, we would be here for a very long time. But it also, I think, particularly notable maybe to this audience that since 1990, Professor Samuelson has been a contributing editor of the Communications of the ACM, a computing professionals journal that's respected for its coverage of existing and emerging technologies, for which he's written more than 70 legally speaking columns. From 1997 to 2002, Professor Samuelson was a fellow of the John D. and Catherine T. MacArthur Foundation. She's a fellow of the Association of Computing Machinery and on the board of a number of other organizations. I should also say, just on a personal note, that Professor Samuelson, in addition to being an incredible scholar and a trailblazer in our field, has been an incredible mentor to young scholars in the field, and I can attest to that personally back in the day when I used to be considered a young scholar. She's really set the tone for our field, and I couldn't be happier that she's here today. Her keynote talk is called Text and Data Mining in the Digital Humanities, and Pam, we're really glad to welcome you here.
Thank you for the opportunity to speak to you today about text and data mining. It's a subject that's has a copyright angle, as we'll see in a few minutes. So I'm going to now share my screen and get started with my talk. Okay. So this is an overview of the talk. I'm going to tell you, if you don't know already, what text and data mining is. There are lots of scientists who use text and data mining to find new knowledge, but my emphasis today is mainly on humanities researchers. So increasingly, there is interest within the humanities of using a set of computational techniques to learn things that you couldn't learn just by reading books. I'm going to talk a little bit about copyright and its fair use doctrine, a little bit about sort of some precedents that support the legality, mention some other nations that have created special exceptions to copyright rules to enable text and data mining. And then I'll talk about why some of the publishers and other copyright owners are not enthusiastic about TDM and raise various issues about it. And I'll then offer some concluding thoughts that suggest that actually those concerns should not drive what the law does about text and data mining. Okay, what is it anyway? So text and data mining is basically a use of a set of automated computational tools that allow you to essentially look for patterns and trends in large quantities of data. The point of doing it is to actually learn new things and learn things that you couldn't learn any other way. So even the European Union has, which is usually stricter on copyright rules than in the US, basically has recognized that text and data mining can promote new knowledge, can support innovation, and is actually something that that policymakers should welcome. There are a very wide array of fields in which text and data mining is happening. But as I said, humanities scholars are now beginning to use the techniques too. And I thought a specific example might help motivate it. So sometime in later this week or sometime in future weeks, you might want to actually go and watch this 4-minute video called The Next Rembrandt. So it's a video about some text and data mining that a collaboration between some Dutch art historians and some computer scientists made to try to sort of think about what one could do if you actually had computerized all of the paintings of Rembrandt. This is a slide from that particular movie, and you can see that there are some things that are characteristic of Rembrandt paintings, so you basically scan all of these things, all these pictures, and then you decide that actually you can select out of all of the eyes and all of the noses and all of the mouths of Rembrandt portraits. You can basically then sort of say, okay, this is a characteristic eye, this is a characteristic mouth, and I think I want to make a new Rembrandt that has this mouth, these eyes, those ears. I want to have a lace collar and a hat, and have the person basically in a particular orientation, which is similar to what Rembrandt would have done. And first, one creates the kind of general outline of what the next Rembrandt might look like, and then you go ahead and paint it, and it does look like a Rembrandt, doesn't it? Only it isn't. Okay, it's actually, it draws from the body of knowledge that that the text and data mining enabled, but it's now a new picture, and you can continue to make new pictures like this with the tools that that this group put together in making this particular portrait. So now you sort of say, okay, that wasn't too hard to do because all of Rembrandt's paintings are in the public domain. So there are no copyright obstacles to do text and data mining on them. But suppose you wanted to do something similar with hundreds of paintings by Pablo Picasso. Then you would actually have to sort of say to yourself, was there going to be a copyright problem with this? And the answer is maybe. So let me talk just briefly about copyright law. I'll give you the kind of the core. Which is that copyright law gives authors exclusive rights to reproduce their work in copies, to make derivative works, and to distribute copies of their works to the public. And those rights last for a very long time, the life of the author plus 70 years. They're subject to some exceptions, and fair use is the principal one I'll be talking about today. And then, as I said, some countries have special TDM exceptions. So what's fair use? Well, fair use is not an infringement. That's one of the things that the statute, the copyright statute says. And Congress basically articulated 4 factors that courts are supposed to consider when trying to make a decision about whether something is a fair use or an infringement. So the first factor is, what's the purpose and character of the challenged use? And the statute basically says, look, if it's criticism, comment, news reporting, teaching, research, and scholarship, those are examples of the kinds of uses that are likely to be fair. Now, just because it's news reporting or teaching doesn't mean that everything goes. The factors have to be balanced against one another. Also favored are kind of non-commercial uses over commercial uses. So doing an academic digital humanities project is more likely than a commercial project maybe to be considered fair uses. And the courts basically say that, you know, if you make a transformative use of a work, a parody, for example, or a caricature of someone, some sort of critical commentary on an underlying work, that's more favored than if you are making just a consumptive use, like when you make copies of music that you like for your phone. So a second factor that is considered is, what kind of work is it? And the courts basically say that highly expressive works tend to have a somewhat narrower scope of fair use than factual or functional works. Then you have to consider, how much did the user take, and think about it not only quantitatively, but also qualitatively. And then you ask yourself, is what the user did, was the amount taken reasonable in light of the purpose that somebody had in doing in making use of the work in the first place? And then you have to consider harms that might happen to the market. And the principal question is whether or not, if you say that this thing is a fair use, how will that affect the market for the original? Will it undercut the market? Will it mean that the copyright owner is less likely to be able to get compensated for what they could, for the original expression that they created? Those are the main questions that one considers in relation to fair use. Now, text and data mining, by its very nature, requires making a lot of copies. So first of all, you gotta either make your own data set by scanning works the way that the Next Rembrandt project did of all the paintings that they could get their hands on that were Rembrandt painting. Sometimes you can get access to a digital repository of works that somebody else actually created, but still, in order to use it, you have to make copies. It's just then the nature of computing to do that. Then you have to format the data, get it in the right shape, kind of get rid of kind of errors or flaws or other sort of kind of noise in the data. Then you make copies when you run queries on the data set. You make copies when you extract knowledge from it, and you make copies even after you extract the data. And the question is whether any or all of these copies are actually fair uses or otherwise non-infringing because they are non-expressive. Now, one thing about TDM researchers is they don't look at books and images the way that most of us do. They conceptualize documents as bags of words. And what they're interested in is bags of words. They want to see how many times does this word appear in the writings of Shakespeare or something else like that. And they also perceive kind of photos and movies and the like as units of data. They have data in them. And so you want to get a large quantity of data because the larger your quantity of data, the more likely it is you're going to be able to learn something useful that would be worth investigating over time. So what we know is that copyright law protects the original expression in a work of authorship, so that when Amanda Gorman gives her inspiring poem at the inauguration, it's the words that she speaks that copyright protects. A performance of Taylor Swift or name your favorite musical star, the sort of the sequence of songs and dances in Hamilton, but facts, data, ideas and concepts are not within the scope of protection that copyright law provides. And so if you conceive of what copyright protects is expressive uses of works, then non-expressive uses may be outside of the scope of copyright. And there are a number of cases which have held that non-expressive uses don't infringe. So one example is if in order to make a computer program compatible with another computer program, if the interface is not publicly available anywhere, is you have to make copies in order to reverse engineer the program that you want to be compatible with to get access to the information about how to make a compatible program. So you extract that information and then you write a new non-infringing program that essentially utilizes that information in order to achieve compatibility. Another case involved the search engines. So a photographer really objected to an image search engine from basically copying images from his website. And the court basically said that the search engine copying of images on the open internet and making thumbnail size images so that when you're looking for photographs of Grand Canyon, you know, the Grand Canyon photos will come up and you'll be able to see the thumbnails and then choose the one that you want. So court said that's not infringement either. And the photographer actually might benefit from more people getting access to the images through the search engine. Yet another case involved the automated in-transit copying of digital files. When somebody sends a file from here to there, from this computer to that computer, it has to go through other computers kind of en route. And that actually is also not an expressive use that would infringe. Backup copying of your computer is another kind of non-expressive use that involves copying, and many kind of incidental uses basically are just not expressive uses that that infringe copyright. Now, the big case that that ended up addressing text and data mining and copyright issues for the first time was a lawsuit brought against Google for Google Book Search having scanned millions and millions of in-copyright books. So Google basically had the vision to create something that it calls Google Book Search. It had good technology to do scanning and to engage in analysis of the contents of the digital books in its repository. And it had the financial resources to basically be able to scan all these books. And it wanted that, that corpus in no small part because it wanted to do text and data mining on the corpus of millions of books. At one point, I think Google sort of estimated that there were a couple hundred million books in the world and that they were going to try to scan every single one of them. Now, they haven't done quite that much, but they still have a very large quantity of digital books in the Google Book Search corpus. Now, Google didn't have the books, so they basically approached a number of research libraries, University of Michigan being the first and primary one. And the University of Michigan was willing to provide Google with access to 8 million books in its collection to digitize. And they didn't have the money to do this. They wanted actually a digital library of their collection. One of the things that made this project possible is that the Supreme Court basically has said that states cannot be sued for money damages in federal court. So state universities might risk being enjoined, but they basically wouldn't have to pay any money. So most of the big partners of the Google Books project were state-related research libraries. Private universities would make their public domain books available, but not very many of the in-copyright books. So Google basically did this scanning of these millions of books, and the libraries got back library digital copies of the books from their collection that Google included in Google Book Search. And then University of Michigan and some of the other Google partners, library partners, decided to essentially create the HathiTrust digital library as a repository for the library digital copies that these libraries got back from Google in order to have one big collection. And right now, you know, the HathiTrust library has something in the neighborhood of 17 million volumes in it. And you can run a search across that database and find every book of the 17 million that actually mentions the person or the historical event that you might be searching for, and it'll tell you the name of the book and some information so that you'll be able to find the reference to that subject when you went to a physical library. And it also, HathiTrust also makes the books in the corpus available to print disabled people. So ordinary people can go to the actual physical library, pull the book off the shelf and read it, but print disabled people can't. So print disabled people can get access from HathiTrust if they show that they in fact are print disabled. So as I said, there was a lawsuit about this. Authors Guild and 3 of its members basically sued on behalf of millions of authors of the books, of the in-copyright books that Google had scanned, basically saying that scanning of all of these books is copyright infringement. You know, how dare you? And so you kind of sort of say, you know, what was Google's purpose? Well, it was commercial. And it was copying works of, you know, millions of works of creative works of all kinds, and you know, copying the entirety of millions of books systematically seems like it's not really a fair use from the standpoint of the Authors Guild, and the harm that the Authors Guild and its members thought was like, well, it's out of control. You know, it's out of our control. It's like copyright is supposed to be about we have control over our work. And now Google's basically appropriating it for its own commercial purpose. And, you know, we would be willing to sort of license something like that, but you kind of made that impossible by just going ahead and copying the books. And because there were so many books being copied, and copyright law allows for awards of statutory damages of up to $150,000 per infringed work. So the Authors Guild was basically looking for $3.6 trillion in damages, and you know, you got to say Google basically was willing to bet the farm on this particular project, but to Authors Guild dismay, both the trial court and the appellate court agreed with Google, not with the Authors Guild. So in the appellate opinion, the court basically says Google made highly transformative use of the books. Now this is interesting because they copied the whole of the text exactly. So what made it transformative was it had a different purpose, right? It was scanning these books in order to discern and then make available information about the book's contents. And you know, the facts of what's in the books is actually not something that copyright gives authors the right to control. And the Google Book Search enabled the knowledge of many new things, and specifically mentioned text and data mining as a whole new field of research that text and data mining was enabling. Court said, you know, if you want to basically index the contents of books and you want to make small amounts of text snippets available in response to search queries, you got to copy the whole thing. So what they did was necessary to achieve their transformative purpose. And while the Authors Guild tried to say, well, you know, you could take this snippet and this snippet and this snippet and this snippet, and then you would like get more expression of the work's contents. And the court said, no, the snippets are just too few and too short to really serve as as a substitute of the original expression in the works, and you just speculated about harm. You didn't show any sort of harm, and so we're basically going to say this is a fair use. The Authors Guild then petitioned the U.S. Supreme Court, and the Supreme Court decided not to review it. So the Authors Guild v. Google case is the kind of the premier case. It's not the only case, but it's the premier case on text and data mining, which suggests that at least the copying in order to do the text and data mining is in fact fair use. Now, as I said earlier, a number of countries have special TDM exceptions. US is not the only country that has an open-ended fair use provision in their national copyright laws, but there are some other countries that basically say, hey, text and data mining is a really good thing, and we think that it ought to be lawful to do, even if it involves some copying of copyrighted material. So Japan, UK, and the EU now all have text and data mining exceptions that that they are making available to people, to researchers, now we come to the objection. So many commercial publishers, Reed Elsevier being one, they have digital repositories of the contents of their copyrighted works, but they see text and data mining as a new value added service for which they would like to be compensated. So they want to be able to control TDM through licensing, and they want to be able to make fees from the text and data mining efforts that people are making. So they basically don't like this idea that it's only non-expressive use or it's only fair use. Also, many copyright owners use technical protection measures to prevent unauthorized copies to be made of ebooks and DVDs, movies, and the like. Back in the 1990s, Congress was persuaded to pass a law that makes it illegal to try to bypass those technical protection measures when copyright owners are using them to protect their works. Now, the Copyright Office under this legislation actually has the power to grant exemptions if they are persuaded that some lawful uses of copyrighted materials are being impeded by technical protection measures. So the Authors Alliance organization, of which I am a co-founder, has asked for an exemption for TDM research to be done. And some of the copyright industry groups have basically said, no way, Jose. So one of the things to know is that if you want to do a digital humanities project on the literature of the 20th century, most of it is still in copyright. You know, there are a lot of projects that people would like to be able to do that would basically affect the works that are still in copyright. And so as part of the petition for an exemption for TDM research, Authors Alliance basically reached out to some of the digital humanities researchers and said, give me some examples of the kinds of research that you'd want to do and you would do if it weren't for the this particular anti-circumvention rule that means that you can't lawfully bypass the ebook technical measure or the DVD technical measure. So what would you try to learn? And the petition basically includes a number of letters from TDM researchers giving specific examples of the kinds of things that actually they want to study. And because these are academic projects, they think that I'm not trying to use the expression from the works. I'm actually just trying to study things and then create new knowledge about what I've learned from text and data mining. And I can't do it any other way. That's the that's part of what they make an argument about. So the Association of American Publishers basically says, oh, yeah, Authors Guild v. Google said it was fair use, but fair use is really decided on a case-by-case basis, and it's too broad to say that copying for TDM purposes is always fair use. So you overgeneralized, it's not really right. Besides, we want to license these uses, and if you can bypass the TPM, that actually means that we won't be able to license those uses in the way that we would really like to. And then they make a number of claims about the exemption request being too broad. But a big part of the sort of concern is the risk of piracy. So, you know, suppose that you end up having a nice database of electronic books, ebooks, that you were able to create this database of stuff. And, you know, what if it leaks out? What if you know, you don't have a good enough security and somebody finds out and then goes loose into the whole world like Napster? That would be terrible. So the kind of risk of piracy is seen as a high risk. And while, you know, the TDM researchers say, oh, we'd be really careful and we would make sure that there was adequate security and so forth, you know, and we respect copyright law, the publishers basically say, yeah, what about SCIHUB? And so some of you out there probably already know SCIHUB. It's a shadow digital library. It's the largest collection of scientific articles in a digital database. And most of those articles, publishers want to keep behind a paywall. And now there's a kind of an effort to basically say, let's shut it down. So they brought, some of the publishers have brought lawsuits against SCIHUB, and SCIHUB was ordered to take it down, but mirror copies of SCIHUB's collection have been out there on the internet. And so it's been able to reemerge. And even many scientific researchers whose institutions actually subscribe to some of the publisher libraries prefer to use SCIHUB because it's just easier to use, and you can do many things with it that on the publisher's platform you really can't do it. So one of my colleagues just wrote a paper basically making the argument that doing TDM research on SCIHUB is not actually a copyright infringement because it's a non-expressive use of the copyright material. Now, nobody, so far as I know, has created a database in copyright literature akin to SCIHUB on the sort of digital humanities side. I think it's pretty unlikely that any of the researchers that we're asking for the exemption for will start one of those things. And in fact, they want to buy the DVDs and they want to buy the ebooks. And so that actually might help the market for the works, not undermine it. And there has been so much new knowledge created based on TDM studies of 18th and 19th century works. The sort of the notion is that maybe there's even more to be learned, much more to be learned from the literature of the 20th and early 21st centuries. So let's get the exemption and see what happens. So my concluding thoughts here. Many of us in the intellectual property field basically look back to the US Constitution and to the purpose that it's supposed to, that copyright is supposed to serve. And that's to promote the progress of knowledge. TDM research unquestionably advances that particular purpose. And while publishers and some authors basically think that, hey, we are the beneficiaries of copyright and we should be able to control everything, the courts basically usually say that the primary aim of copyright law is to promote the progress of science, of useful arts, and to benefit the public, right? Get more knowledge out there to people in the public. And digital humanities scholars are actually enabling whole new ways of thinking about texts and data, able to discern things out of a corpus of millions of copies of works, and to understand the relationship between works and how they communicate in some sense, right? Many works are basically responses to other works. And so there's a lot to be learned if we can enable digital humanities as well as digital science. And so this is my plea that copyright should not be an obstacle to opening the keys to cultural studies. So that's my sort of opening remarks. And
That's great. Thank you, Pam. So we have like about 20 minutes to do some questions that are specifically related to Professor Samuelson's talk. You can use the Q&A function and send them in. There's a couple coming in. So I'm going to get us started, Pam. It's up, where you ended is sort of a good segue to a couple of the questions that came in, which is sort of fair use is kind of all about balance, right? It's all about sort of trying to balance the value of the new use, or the kind of the use that people would like to make of the work, against the expectations or the value of the authors. And so, one of the questions is sort of like, how do we know what the right balance is there when it's a new technology, in particular, and a new kind of use that we've had before, right? So I've seen lots of work in the past about patterns and fair use. Some of your great work on that too. But how do we know how to do that with new technologies?
So, so the Association of American Publishers is right that we have to sort of do a case-by-case analysis. And if you kind of think about what the factors are, sort of what is your purpose? The more your purpose is to advance knowledge, that sort of tips in favor. If you're in fact undermining, though, the same use that promotes knowledge, right? SCIHUB promotes knowledge, but it also undercuts the market for the licensed versions, and so that's a place where the courts will basically say it's too much of an impediment. So one of the main reasons that in the Authors Guild v. Google case that the Second Circuit Court of Appeals decided that this was not infringement was because mostly people are just looking for information. They're not trying to read the work, and you can't get enough of the original expression from the work that's in copyright in the Google Books corpus to basically satisfy your demand for the work. So that's what you have to do. I think the purpose and the sort of the harm to the copyright owners uses, but many of the sort of the fair use cases have involved this balancing process. And another one of the big cases involving fair use in new technologies was the 1984 Sony Betamax case, right? So Universal City Studios basically sued Sony for making this Betamax machine that enabled people to make copies of movies and other television programs for watching at a later time, or even for making little library copies of them. And the Supreme Court basically said, yeah, they're making copies of the whole movie, but they're doing it just for time shifting purposes mainly. And you were already authorized to watch that program in the first place, so you're just watching it at a later time. And there's not, at that time there was no market for private copying, and the courts still grapple with that, but to the extent that it's a private copy, and not one that can then be re-disseminated broadly the way that Napster did, right? So Napster is actually an example of not fair use, because not only was somebody able to make a personal use copy of music that they liked, but they basically could share their music with everybody, and everybody could share with everybody. And all of a sudden there are kind of billions of infringing files out there. So that's an example where it undercut the market rather than just being in balance.
So I know this won't surprise you, but several of the questions have come in are basically asking you for a little more certainty about what the results are going to be like. So let me ask it as a general question, and then I'll give you some of the specific ones, which is basically like, how confident could a library be in your assessment that text and data mining is fair use? Like, do you feel like that's sufficiently well established that they could be confident? And if it's not, is there a way to make it more concrete other than giving sort of the exemptions you were talking about to the technological protection measures?
So I think that I would say that confidence could be pretty high. I focused on the Authors Guild, the Google case, but there are several other cases. I try to give you examples of the non-expressive uses that have been litigated in some of the prior cases. And there are, I would say, the scholarly consensus, there are at least half a dozen articles that have been written by people whose work I respect, who make the argument. So Mark Lemley has a piece on fair learning. Mike Carroll just has a new piece out in UC Davis Law Review about the right to do text and data mining. Matt Sagg has written a couple of papers basically arguing, and these are all extremely well-respected people, and I'm drawing heavily from their work, but they have made the sort of the more specific arguments, and I'd certainly be happy to give anyone who is interested the sort of the quick view of the literature, so that someone else can sort of say, it's not just Pam Samuelson that's saying.
Yeah. Okay, so pushing on the sort of, you have to do the kind of very specific case-by-case analysis. Someone was asking sort of, how would you know where to draw the line here? So text and data mining is good. What about mining photographs like used for facial recognition algorithms? Is scraping and mining photographs, is that also fair use? And what kind of considerations would you want to think about there?
So this is a really, really interesting question. Certainly, it's also for a transformative purpose. It's not the same purpose as the photographs were taken for in the first place. Courts haven't actually addressed the sort of that, but I think that there are a couple of cases involving image search, and the image search technologies have actually been right, the sort of this Kelly versus Aribasoft and the Perfect 10 versus Google cases are actually, pretty strong, again, highly transformative, and it's not undercutting the market for the work. Now, whether that's a privacy violation is, I think, a separate question, and certainly, where those images are to be found is a question. Did you get lawful access to it? I think the more you get lawful access to the photographs, the more likely it is on copyright grounds to be a fair use. But if you're getting access to by stealing somebody's collection of photographs, that would actually be a different matter, it seems to me.
That's a good segue, because a couple of people were interested in knowing a little bit more about the sort of details of the exemption that you were seeking, in terms of like, how are you defining text and data mining? Like what things were sort of clearly within the scope of that exemption and not? And then others sort of relatedly asked if you could say a little more about what the details of the exemptions are in the other countries that you referred to.
Okay, so the text and data mining doesn't have a kind of a stable definition, but the petition is basically tries to talk about what the text and data mining scholars that they were putting the petition together for, what they think text and data mining is. So it's use of certain kind of computational tools to engage in analysis of large quantities of data. That's the kind of the short version of it. Because the petition has been filed, there's been then these responses by these three organizations. So they're basically saying it's too broad, it's too broad, it's too broad. So the reply to to the opposition is going to be filed in mid-March. And so I expect that the text and data mining exception will be that that's being requested will be more specifically defined and may be limited to academic research, may be limited to situations in which you can basically say, you know, here are the security measures that we promise to take in order to make sure that piracy isn't going to happen. So those are examples of the kinds of things. I'm certainly happy to send a copy of the petition to anyone who might be interested in looking at it. As for the text and data mining exemptions in other countries, the one in Japan is actually extremely broad. So it applies to all researchers and not just to non-commercial. So the UK only applies to non-commercial kind of research, text and data mining for scientific purposes. And it also is limited to, you have lawful access to the material. So text and data mining under the UK exemption, for example, if you were trying to do it on SCIHUB, that would not fall within that exemption. The EU basically has two exemptions, one for the kind of nonprofit scientific research and cultural institution, TDM, right, the nonprofit side of TDM, and that's very broad. It's not only basically says it's a mandatory exception, so every one of the member states of the EU basically have to enact that into their national legislation, but also it's not overridable by contract. And one of the things that limits TDM right now in the US, at least to some degree, is that we don't have a kind of non-overridable by contract rule in respect of TDM or pretty much anything else. So that's a difference. Now, over the course of the originally the European Union was only going to have one exemption for TDM to do nonprofit work and research. And then a lot of the commercial companies that want to do AI said, hey, we need to be able to do TDM too. So a second exemption was added, but it's not overridable by contract. So it's anybody can take advantage of it, but contracts can override it. So it doesn't have the same scope. And also they have a lawful access to the data too.
Okay, super helpful. Two questions I think are maybe related to, I'll just do one at a time, which is one question about whether you think there's any merit to the concern that an exemption for text and data mining would weaken TPM for ebooks more generally. Are there any legitimate concerns there?
It's not that hard actually to find a tool out there in the world that will allow you to get access to ebooks. So the researchers didn't, who were supporting our exemption, basically didn't say, oh, you know, we wouldn't be able to do it anyway because we don't know how to code. So I think there's just no question that that there are tools out there already, and you know there is some leakage of ebooks and some leakage of obviously of DVD movies and the like. I don't see the TDM exemption really weakening this. It's just that now some of the people who have legitimate reasons to use it would be able to do it because right now they're withholding certain research projects because they don't want to violate the law. Now, you know, I will tell you that one of my colleagues who is doing a casebook basically wanted to sort of show some parts of movies in order to be able to kind of show how movies kind of, you know, dealt with kind of objections, you know, evidentiary objections and the like. And so he went ahead and just did it. and put it on a CD-ROM. And I said, I guess you never heard of 1201, which is the anti-circumvention rule. So there are people out there, but the text and data mining people actually know about this anti-circumvention rule, and they're right now not doing it. At least that's what they say, because they want to respect the law, but they think that it's impeding this lawful use that should be made.
The digital humanities people are rule followers, so they don't do. So one question that came in is about streaming, right? So you're talking a lot about sort of access to works that exist in some stable form. And the question is, how would you sort of think about whether the considerations are different if someone were trying to say, like, analyze color patterns in a set of films that are only available by streaming service? Like, does that change the calculus for you?
Well, that's going to actually be a place where contract is going to be probably playing a pretty big role. So if you can't get lawful access to the streaming in order to do TDM, the entity that's controlling the streaming is the entity that basically will use contract in order to stop that. I mean, they'll probably use technical protection measures also, but I don't think that the exemption being sought here is so broad that it would cover streaming services.
Okay, I'm going to ask you one more, and then we'll have time to sort of transition over to our roundtable. And that is this, which is a little bit down in the weeds. But so the Google Books case you talked about, and some of these other ones, they lean pretty hard on transformative purpose as opposed to sort of transformation of the work themselves. And so one question is sort of, how is that concept being used there only because it has sort of particular salience there, or do you see that as being sort of a move in fair use law in general, that transformative purpose counts as transformation?
So I have actually been one of the people who said that different purpose cases should be treated differently than things like parodies, where a parody is transformative because it takes some of the expression from a work and then injects it into a new work with some different character, right? So the parody kind of changes your perception about the original, and it's a kind of critical commentary, and that's the conventional kind of transformative work. But when the Supreme Court in the Campbell versus Jacob Rose decision decided that transformativeness was important to fair use, they talked about having a different purpose. So it's consistent with the Supreme Court's case law to say that having a different purpose is actually something that should be taken into account. And the cases that are closest to the TDM problem are all ones where, here's the purpose that you had of writing the book in the first place, right? You want to communicate the original expression. I'm not doing it for that purpose. I'm doing it for a different purpose. And because I'm not doing it for the same purpose, it's unlikely that the secondary use will actually undermine or supersede demand for the original. So in fact, if you find a book on Google Book Search that mentions something that you want to do research on, you're more likely to buy the book or at least get it out of the library because now you know it exists. And when the Authors Guild, the Google case was pending before the Second Circuit, the Authors Alliance actually filed a brief in support of Google's fair use defense. Basically, a number of our members of our advisory board basically said, our books are in the Google Book Search corpus and we want people to find our books. And that's what Google Books Search was for, was to enable people to find the books that actually mentioned whatever it is that they were looking for.
I feel like I hope I remember this right, that I saw in one of the objections that some of the music publishers had filed against iTunes you remember when they made their preview longer, like instead of it being 10 seconds, it was like 20 seconds or something. And I feel like if I remember right, that Apple was able to show actually that the previews actually, they increased the sales of the downloads of the music, that the more people had access to be able to listen to it before they bought it, it actually increased the number of, so that seems like that's a pretty consistent pattern you just described.
Yep.
Yeah. Okay, so we're going to shift, and I'm going to bring some of my colleagues in here. Just for all of you guys who are watching along, the Q&A thing is still open, so feel free to send them in. So I'm going to introduce very briefly a couple of other people that we're going to add, and then I'm going to give Pam, I hope you'll stick around with us too, because you get to be part of the roundtable too. So what I'm going to do is introduce each of the three people here very briefly, and then I'm going to invite each of them to spend a few minutes just kind of reacting to the talk and giving some introductory remarks, and then we'll do some questions and answers. So first is Natalie Meyers, who's an e-research librarian in the Navari Family Center for Digital Scholarship, where she helps pioneer and provide research data consulting services, including more in-depth data management services in support of grant-funded research. Katie Walden is assistant teaching professor in American Studies. She received her PhD in American Studies and Sports Studies at the University of Iowa, where she also earned an MA in Library and Information Science with a certificate in Public Digital Humanities. And finally, Elliott Visconsi is Associate Professor of English and Associate Provost and Chief Academic Digital Officer at Notre Dame. He's a scholar of early American literature, freedom of expression, and First Amendment law. So you guys are all cameras on here. Katie's got the nice background there. So maybe why don't we go in that order? We'll do Natalie first, and then Katie, and then Elliott. And if you guys want to just each give some reactions, and then we'll just have a conversation.
Thank you so much, Mark. That's great. I wondered if I might share in the chat a link to some slides. This will help people go back to some of the remarks I'll make and things I'd like to sort of riff off from Pam's talk. Like the introduction described, as interim director of the Navari Family Center for Digital Scholarship, I work with students, researchers, teaching professors every day to help them achieve their digital scholarship goals with text mining, software and emulation. And in each of those, we encounter use cases for the kind of non-consumptive and transformative explorations of authored content that Pam described as fair use permissible. I like to bring a few of those to your attention. One of them is a COVID-19 high performance computing consortium supported project for text mining Cord-19 with a locally developed text analysis tool my colleague Erin Morgett built called Distant Reader. With Distant Reader, we were able to text mine the Cord-19 corpus. It's a resource of over 400,000 scholarly articles, including about 150,000 with full text about COVID-19, SARS-CoV-2, and related coronaviruses. This freely available data set was provided to the global research community to apply recent advances in natural language processing and other AI techniques so that we could generate new insights in support of the ongoing fight against COVID-19. Those allowing their articles to be text mined through this project supply their metadata in a separate file which accompanies the distribution of Cord-19. But what that does is complicate knowing how long the articles persist and how to engage with them. It's been a really challenging project as the number of articles has grown. The fire hose hasn't slowed down. Another use case we have was using the same tool, Distant Reader, to text mine survey responses. And here we got into murkier territory. It was an open Qualtrics data set. We could simply download it and text mine it. But then one of the questions invited respondents to provide URLs to their websites, saying whether they'd close their campus libraries in response to the COVID-19 pandemic. by April 2020, most libraries were reporting they were closed in their survey responses, but when we text mined their websites, they quite often didn't come right out and say that. Instead, they wanted to say that their services were available, even though they weren't holding open hours. But that contradiction wouldn't have been apparent to users of their websites or to readers of the survey unless we've been able to text mine both. A couple other use cases we have are related to emulation as service. We've participated with the Software Preservation Network and Yale University on emulating Douglas Adams' Last Chance to See book. It was one of the first ebooks. And we currently have an award to repair and expand Douglas Adams' incomplete sequel game to Hitchhiker's Guide to the Galaxy, otherwise known as Milliways. And in that project, we have a piece of software code that was not complete at the time of Adams' death, where we received an award to literally finish the game and make it playable. It's a transformative use because the game was quite rudimentary when it was left. But it will be interesting to see how allowing others to play it might or might not have copyright implications. So I'd love to hear Pam and others' response to any of those use cases. And I really appreciated hearing recently about how University of California has issued a revised copyright ownership policy of its own. A few elements of that policy that caught my attention were expanding the eligibility of members of the university community and its definition of academic authors that both simplifies and expands the pool of those eligible to own copyright, and the way that the revised policy expands and clarifies the pool of works eligible for copyright ownership, including a definition of scholarly and aesthetic works that did not exist in the 92 policy that clarifies that software is a work for which certain eligible employees may own the copyright. So I'd love to hear more about any of these things and welcome your responses.
Great, Katie.
Hi, all. I just want to say first off that I'm grateful and excited to be part of this conversation and want to in particular note the work of Felicia and Monica, ND Studios, and other relevant units who have done a lot of legwork behind the scenes to convene these people and facilitate this conversation. So thank you all for that work. I think my remarks might take us in a bit of a different direction, drawing on my own experience and interdisciplinary background, as well as thinking about kind of when we cast a large tent for what falls under the umbrella of digital humanities, and we start thinking expansively about what data looks like within that, what questions about modes of scholarly knowledge production, questions of digital preservation start to emerge. So I'm going to maybe ask a different set of questions that build on the conversation we're having. And I think one thing that has been interesting as I'm listening to Professor Samuelson's talk, I think oftentimes when we're using this language of the digital humanities, oftentimes that can be elided with computational literary studies or textual studies in ways that it's a logical step to make when we're thinking about what digital humanities research looks like. But as someone whose background is maybe a little bit more in the mixed methods social sciences, I think one of the things that we think about when we're looking at the intersection of text and data mining is, when are we representing data as text, and when maybe are we engaging with other forms of data that maybe are not textual information? So I think, when we're thinking about computational or digital methodologies, text is certainly a robust body of source material. But I think when we look at, for example, the quantitative social sciences, we're seeing examples of other kinds of work that methodologically is adjacent to the work of data mining, but just might be coming from a different disciplinary valence point. And so I think that leads us to ask kind of a different and broader set of questions about when we're using the language of data mining, what actual data is being mined. And again, thinking about some of the methods that might come to us out of the quantitative social sciences. In some cases, we might be working with data sets like Census Bureau data or ICPSR data or other things like that, that are open for a variety of different reasons, whether they're open by federal mandate, taxpayer funding, grant structures, other consortial research efforts. But I think in other cases, we can run into situations where the relationship of the data with our existing frameworks for thinking about access and copyright and intellectual property maybe gets to be a little bit more fuzzy. And the example that comes from my own background is the research that I've been working on since I was in graduate school works with sport data. And I'm happy to say more about this in the Q&A or follow-up conversations. But as a graduate student, I became interested in a set of more kind of mixed method social science questions coming out of cultural studies that I really needed a large data set that I could mine and analyze and interact with, and found very quickly that while the legal precedent coming out of the Eighth Circuit says that baseball data in particular, the discrete numbers, are public record, the way that they are formatted and presented and stored and made available is something that can be licensed. And so that raises a whole interesting set of questions when we're talking about what qualifies as a transformative use. On one hand, you know, the discrete pieces of information, the numbers, the values, might theoretically be in the public domain, but if our only way to access them is through these digital interfaces or representations, there's many questions that come out of that related to how do we make sure that labor is credited and acknowledged and compensated, things on the internet don't just exist there for free. So when we think kind of more broadly about what might fall under the data for data mining, it raises another set of questions about what transformative use looks like, what fair use looks like. I think there's also a question here when we're using the language of digital humanities, and this event is co-sponsored by our Center for Digital Scholarship. We're also thinking about different modes of scholarly knowledge production, and particularly thinking about some of the emerging conversations coming to a head within digital humanities and digital scholarship and scholarly communications. We're thinking about, as folks coming from perhaps more traditional humanities disciplines are starting to engage these computational methodologies, where do questions of reproducibility, transparency, where are those values showing up in the scholarly research methodologies, but also what does that look like for research that becomes part of the scholarly record. So thinking about if someone, let's say, you know, an English PhD candidate or a junior scholar is engaging in computational methodology that involves text and data mining, theoretically, they could make their RStudio scripts, their Python scripts open access. If others had access to the same corpus and data set, they could reproduce some of that analysis. But this becomes really slippery really quick when we're talking about perhaps bespoke data sets or corpuses that someone is scraping off of a social media platform that maybe can't be shared. So this is a larger set of questions or tensions when we're thinking about the relationship of digital humanities and digital scholarship. What kinds of scholarly knowledge production are we talking about? And, you know, thinking about some of the research methodologies or values that come out of the open science movement, where does transparency come in, and where does that exist perhaps in tension with questions around or traditional modes of thinking about fair use and intellectual property? I think the last kind of big theme that I'll mention is, you know, when we're talking about scholarly knowledge production, we're thinking about the different modes in which research gets represented. This again raises a variety of interesting questions around how actually transparent can you be if you're writing an article for a humanities journal. We're starting to see under the umbrella of digital humanities things like GitHub repositories that go along with a scholarly article that are making code and data available, but it's definitely kind of a set of scholarly communication norms that is continuing to evolve. And again, it's coming back to where are we drawing on research methodologies and values coming to us from other disciplines, particularly the open science movement, but not exclusively. And when we're thinking about potentially graduate students or junior scholars who on one hand want to make their work open and accessible and follow these emerging kind of research methodological values within the digital humanities, but also have publishing agendas or research agendas that they're trying to curate, it raises a really interesting set of questions around different prioritization of what knowledge production looks like, of what sharing information looks like. And particularly when we're thinking about the digital humanities, we're maybe starting to see some slippages or tensions between NEH funding guidelines that are requiring data to be open and you to have a data management plan, and the fact that our existing copyright and intellectual property law framework may say that for the specific type of project you're doing, you cannot make your full data available. So some nuances and fissures, particularly, you know, my experience was running into this as a graduate student. What does this look like when you're on a particular time to degree, or what does it look like when you're trying to publish your research in spaces where you can't make everything available, but yet you're hearing and starting to think about different research methodologies that call for transparency, reproducibility, and openness in ways that are maybe new to other kinds of humanities methodologies. So lots of questions and maybe a couple of different directions that we could go in.
Great, thanks, Katie. Elliott?
Well, thanks for having me. I'm really delighted to be here, and I really loved your talk, Pam. Thank you for that. Really stimulating discussion. So I have 4 things I wanted to talk about very briefly, one of which I'm just going to try and connect on the fly to Katie's last point, which is I do think that we, in and beyond the humanities, have an obligation to think hard about some of those institutional contexts and questions, such as not only, you know, the invisibility of labor and the infrastructure that it takes to do this work, but also how we as scholars think about the evaluation, credentialing, and long-term sustainability of these projects, because there are many digital humanities projects, including and not limited to text and data mining projects, that have a short shelf life and then vanish into the ether. I have some personal experience with that, and I think that with an audience of librarians, I don't think I need to belabor the point of why that's a problem. So that's one thing. One of the other questions I had, just sort of thinking about the broad framework and the sort of the direction of the argument, which I'm completely in favor of, Pam, that you're advancing here, is to sort of ask a question about the differentiation of genres. And that is to say, among the copyright industries, there's this sort of general fear of piracy and general fear of leakage and slippage. And I wonder if when we're thinking specifically about textual data, that is to say books and so on, if the conflation of anxieties on behalf of the copyright industry is actually occluding from view some potential remedies, right? So that if you think that everything is the same kind of piracy, that you know, video and music and text are all versions of IP piracy, you might sort of see it, if you're in the copyright industry, you might well see it as the same problem to be solved with the same tools. And so I thought it might be a useful thing for our roundtable to sort of think about media segmentation or differentiation as a way of thinking forward towards some of the other points you asked us to think about. The second sort of theme, and again, this is pretty much just a live response to your wonderful talk, but is sort of to ask us to think more broadly about what is the right disciplinary home for text and data mining. And so as Mark said, I come out of an English department, and within the English departments in general, there are practitioners who are very interested in text and data mining, and there are a whole lot of people who aren't, and who are suspicious of the basic premises of TDM, because in some ways it cuts against the grain of aspects of the fundamental disciplinary orientation towards focus on a small number of exemplary works and the influence and the, you know, networks that they exist in and so on. I know this is all well known, but the sort of the notion that you're applying some analytical frameworks to a bag of words is anathema to aspects of the literary discipline. And that's not to say that, you know, that should be approved, but it does describe a schism within the discipline itself. And so I wonder if that actually supports aspects of the copyright industry's argument as you've laid them out for us, because the copyright industry also sort of valorizes the individual reading experience, that the sort of the exemplarity of the text, all of these sort of questions. And so there's a kind of traditionalism in the literary discipline that ironically, because I think most people in literary studies are very much in favor of expanded access to knowledge and transformative uses and so on. But I think ironically, there may be some interesting sort of parallels between the norms of the discipline and the ways in which the copyright industry advances its arguments about exemplarity, about utility, and the risk of the piracy to the one, so that you sort of control the many, as it were. So those are sort of two initial reactions. I mean, another way of putting it, do you need literary scholars to make the argument, or is the argument going to be more effective coming out of a data science, computational informatics sort of world? And I don't say that to try and dismiss my own discipline. But the third point, and this is where I'll stop, I think goes to your next to last slide, which has to do with the culture hub idea that you were proposing. And I wonder, I would love to just sort of hear you talk a little bit more, and maybe all of us can reflect a little bit more on some sort of the academic version of industrial self-regulation. That is to say, is there a version of SCIHUB that is advanced by major research libraries, by academics who are doing this work and who can collectively put the copyright industry in a more comfortable place as a collaboration with them? I don't know the answer, but I think that that's where you were gesturing. And I know that libraries are already doing a lot of this work. I mean, that's sort of in their DNA, but if there's a single hub, maybe that would be more securable. I don't know. But I really like the gesture that you were making towards the end at some sort of consolidated repository that might provide a degree of comfort for the anxious copyright industry, and also a common gathering place for academics who are doing this serious and important work, which is, I think, absolutely, as you laid out, going to really advance knowledge for all of us. So those are sort of three thematic questions, mostly for you, but I hope will be the basis for some connections with our other panelists and for a really robust discussion. So thanks again.
Elliott, lots there. I just want to remind you at the beginning, you said 4 things. I just want to know if you forgot one that you wanted to add now or not.
The first one was about institutions. So
okay.
It was more of like a phrase.
3A, yeah, okay. Great, so I just want to invite you guys, anyone who wants to react, and definitely people did not come here to listen to me talk. So if we want to react, I know Pam, there was a lot directed at you there. I don't want to put you on the spot, but if you want to pick out any in particular that struck you.
Oh, so let me actually respond to Elliott's, a couple of Elliott's points. So there was actually a culture hub of sorts that the publishers actually were very supportive of back in the early 2000s when Google and the Association of American Publishers and the Authors Guild got together and had a Google Book settlement. They proposed actually that Google's corpus would actually be a kind of culture hub, and that there would be institutional subscriptions that that research institutions could do, and what they were then calling non-consumptive research projects that people could basically sort of sign up for doing TDM type analysis on the corpus of however many millions of books that were going to be in this corpus. I think at the time they were kind of thinking 100 million books. So 100 million books would be kind of like really pretty cool. And of course, if Google was basically controlling it, they have really good security, and they could set the security standards for any kind of mirroring of the site of the corpus. So so that was actually something, and the idea was that the institutional subscription money would go to this sort of 38% of the money that Google collected would stay with Google, and then the other money would basically be thrown over the wall to a new collecting society, and the Authors Guild and the publishers would be on the board and basically decide how to allocate that money back to the authors whose works were being used. It was a really, really clever deal. I were against it for a whole bunch of reasons, which I won't go into right now. But I'd love to see something like that happen. And in fact, I actually wrote after the Google Books settlement basically failed. I sort of developed a kind of an architecture for how something like this could actually be created. So our thoughts run along the same lines in that respect. In respect of the question about disciplinary harm, one of the things that's happened at Berkeley is that because data science and text and data mining, digital humanities stuff was happening all over the campus, a group of faculty got together and said, let's create a new division of Berkeley. And so people could basically be housed in, let's say, the English department or Slavic languages, but also have an affiliation with the data science division. And so we're in early stages in respect of this experiment, but it was a reaction to the sense of many of the people who are disciplinary based, that they wanted to have a bigger connection. And also the people who are kind of like pushing the data science division have developed a set of modules and training materials so that people who don't currently have the skill set to do text and data mining could acquire it so that then they could do it. And so some of my colleagues at the law school who are doing empirical work have actually been taking those classes and now expanding the methods that they really feel like they can comfortably do. So that's a couple of kind of responses. And in terms of sort of the copyright industries, I mean, it's the motion picture industry and the Association of Publishers, American publishers. They're the people who basically are the most active, and the motion picture industry way more. So I think they don't care what's going to happen with certain kinds of works, but they care a lot about anything that seems like a chink in the hole, a chink in the wall that would make for more piracy happening. Now, there is a lot of infringement out there on the internet. There's no question about that. But when it comes to scientific and technical work, SCIHUB is really the kind of the big actor out there. And one of the reasons why people are attracted to SCIHUB is because it's the most complete collection, right? Each of the sort of major publishers basically wants to have its own kind of like repository, and you have to subscribe to it. But the Elsevier one doesn't kind of, shall I say, interoperate with the Springer one. And so if you really want to be able to run, queries across a big set of data, a big corpus of works, SCIHUB is for you. And there are no license fees and no restrictions on what kind of TDM you can do. So, so that's actually, that's just the fact of life, right? Now, would that be true with Culture Hub? I'm not sure, but somebody has to be brazen enough to get their hands on the corpus and then run it off servers around the world. Kazakhstan doesn't have quite as active a copyright industry lobby as the US does.
So one thing that this is probably an obvious thing to say, but it's just because it was a thread that I heard in, I think, all the comments there was about the way that, this is more than just a copyright question, that especially on a college campus, that the answers to these questions and the access in very meaningful sense shapes what a discipline is, right? Like it, in fact, like enables certain kinds of research or disables other kinds of research. And, maybe as Elliott says, that sort of tracks, sort of predispositions about it. But, as Katie was talking about, like in some cases, it will substantially affect the kinds of questions you're able to ask, even in sort of one discipline versus another. So I guess I just thought I would invite some reactions to that, that this is, there's sort of like a very, like a lot of copyright fights often feel like, some entity that makes money versus some other people who want to get it for free, right? But in this case, like, it's pretty easy to see the sort of cultural consequences in an academic environment in terms of like the kinds of things that are enabled and disabled, and what that means about sort of what disciplines are now and what they become as time goes on.
Well, and I'll jump in. I think this connects kind of a point that Pam was making and Elliott's comment about kind of institutions and institutional structures, thinking about, you might have faculty in English who would be affiliated with a data science unit, but if their primary tenure line is still within English and that's their structure for tenure and promotion, it's a different audience for their materials that might not even be the audience they're in conversation with at the institutional level in terms of the work that they're doing. So it raises really interesting questions to the point you just made, Mark. While we can have potentially interdisciplinary centers or units or kind of environments of affinity and interdisciplinary conversation, those structures of tenure and promotion and the audience for scholarship and who's determining kind of what counts as scholarship in a discipline. I think on one hand, particularly for graduate students and junior scholars, that puts some boundaries in place in terms of the strategic choices you have to make around where your work gets published and who's the audience for your work, just with those larger structures in mind. I think it also shapes, when we're thinking expansively about the kinds of digital scholarship products that might come out of this work, you also make strategic choices around what knowledge production is legitimated and recognized in your discipline, which again surfaces different sets of questions around transparency, reproducibility, and what publishing looks like.
Yeah, so there's already been, I think, a real transition, at least at Berkeley, and I think more generally, of basically saying, it used to be that that books were the coin of the realm, and what if something is a kind of an open access work? How are you going to get quality control? And are people going to be, are young scholars going to be penalized for kind of making their work available on an open access basis instead of through kind of the leading journal in blah, blah, blah field is this Elsevier journal. And if you want to get tenure, this is where you're supposed to place. And so that changing the kind of the views of the sort of the more senior people, that basically the open access, I think we've made a lot of progress, I think, on that one. And I think that the digital humanities is kind of a next wave of, okay, we just got used to adapting to this thing, now we have to adapt to that thing. I think the reproducibility issues are really super interesting. So I'm really glad that you brought them up. Certainly the reproducibility norm of kind of conventional science has been not easy to fulfill. And it's really taken a lot of pressure from NIH and from some of the major foundations that you got to make your data and you got to make your outputs available so that we can see whether in fact people can reproduce. And so that's actually something which is just another one of these as you say, tensions, struggles that fields are basically having to go through. And I thought it was really interesting you mentioning the kind of the GitHub repository as a kind of a place to host some things, and that's certainly not the conventional norm. But it does seem to me that that part of what's interesting to me about especially digital humanities is that it's happening, even though it may be a little scary for some of the junior people who are in the field. So despite the fact that it's it's kind of novel and it kind of makes some of the more senior people who don't have those skills and that orientation getting them to sort of open their minds and basically, but now I think there are enough people who are doing digital humanities that, when somebody's coming up for tenure, you can say, this person at the University of Michigan, this person at Cornell, this person at Notre Dame, you could be able to identify people who are leading researchers in that, and at least get letters that basically say the work is of high quality and is contributing knowledge in a different way, but still contributing knowledge in a very valuable way.
Yeah, Natalie, so I wondered if I could ask you to say a little more about these use cases that you have for text and data mining and basically where you get them, right? So, Katie is describing before some challenges because it seemed like the sort of central examples of text and data mining kind of, were adjacent to what she was interested in. So I wonder the extent to which you're kind of eliciting those from faculty who are interested in doing this kind of work and whether you're trying to push the boundaries on it, or like, where do you get the use cases?
That's a great question. And in the Center for Digital Scholarship at Notre Dame, the use cases can come from students or faculty, from faculty interested in teaching and ways to onboard students to digital humanities tools, or they can come from faculty with their researcher hat on who are trying to tackle specific problems, like, for example, methods for doing wastewater surveillance for COVID-19. In cases like that, the literature is coming so fast and furious, you need ways to get a handle on when people publish new approaches to your topic, and you need quick ways to do named entity extraction around that or geographic place name extraction. So you're driven by pragmatism. Other times, like in the COVID-19 data set project, we had a software tool developed in the Center for exploring corpora in the digital humanities primarily. And that tool was repurposed over a period of about 4 months for use on scientific journal articles because the COVID-19 consortium identified a need for such tools for scientific researchers that were easily transported to different HPC. We were able to run our tool through an award from the HPC consortium at Compute at Los Alamos National Lab, at Exceed, and at Microsoft's AI for Good. And one of the things in that case that appealed to the grant makers was that we had a tool that was already portable enough to work on a corpus the size of Cord-19 that had value in its outputs for researchers, regardless of whether they were working on host genomics, virus genomics, surveillance, and so on. And that was really an exciting project to work on, but it had its basis in classroom explorations around Walden Pond. It didn't start tackling a giant scientific corpus. And when we look at the extensions of using emulation and analysis inside software, when we reuse software, the use cases get more complicated pretty quickly, not just in terms of owner rights, but in terms of where can you run that emulation, who can access it, do you have the right to offer that software in reuse to others? And it gets a little more complicated pretty quickly. Those use cases can be driven by a scholarly question. In our case, could this old game be reinvented? It's a question that was being asked at Rutgers that one of our researchers was interested in. So the questions seem to spring from disciplinary exploration or a pragmatic need to tackle a scientific problem or a problem that you think a corpus can unlock.
Sorry, it's like, Katie, maybe you need to bring some of your challenges over there.
Say what?
I said maybe you need to take some of the challenges you were describing over to the library. Make use of it.
Libraries are always wonderful partners, just to think through what services we might have access to, what models do we have for digital preservation and research data management. Yep.
Yeah.
And I loved, Katie, how you or someone was emphasizing in the chat access to JSTOR data for research, Tahathi Trust Research Data Center, and how those data capsules that you can make at Hathi Trust Research Center, or the way you can interact with the corpus on JSTOR, give us examples of what these collaboratives might be like. Gale Scholars Lab is another example, but again, they're sort of like big silos right now.
Elliott, I wondered if you might say a little more about what you had in mind when you were talking about media segmentation and opening up new things. Because one description of fair use might be that it is already sensitive to sort of different types of media and different kinds of settings. So what did you have in mind there?
Yeah, I mean, it's more about the, I guess I would say the blunt instrument that sometimes you see the copyright industry bringing to bear, or just the blanket thinking about piracy. Right, so a piece of music is very, very shareable in digital form because it's really short, right? I mean, that's an exaggeration, but a film is a little harder, but nonetheless, there's rampant piracy, as everybody is well aware. Books are more easily converted into metadata, as Pam was pointing out, that snippets and other forms of data become metadata. That's one of the nice features of that kind of the Google Books approach to creating their transformative works and so on. So I didn't have much more to say about it than simply that it seems like that often in the popular understanding, there's a kind of anxiety about piracy that takes an analogy and then uses it to reason across into, let's say, controls put on books that might be better used for film or media or so forth. So, but no, I mean, you're right. Of course, when you do a 4 factors test, you find that, the nature of takings and so on is going to vary widely.
So one factor that actually we haven't talked about that I think is worth keeping in mind, and that is that the concentration of industries in the motion picture industry and the recording industry, to some extent now in the publishing industry. So a lot of these companies, there used to be hundreds of publishers, and now they're a smaller number, especially sort of the bigger ones. A lot of the complaints about sort of internet piracy, though, have come from photographers. And photographers don't really have, right? Each photographer, more or less, is an independent contractor or independent actor. And while they've tried to form some kind of, collective of photographers, they haven't really been able to, get everybody together. And the same thing, there's a collective for science fiction writers out there, but it's just a few people. I mean, even the Authors Guild, which has about 10,000 members the last time I looked, is a small player when there are millions of authors. And one of the reasons why I decided that Authors Alliance was an organization that needed to exist was that the Authors Guild kept basically making all these public pronouncements about what authors need, what authors need, what authors need, as though they were the only people who are authors, and as though they were the only ones whose perspective on copyright issues should be given any kind of deference. So, so our membership is, it's a young organization, but we have a couple thousand members now, and as we grow the organization, I think we are able to take on a little bit more. And so we've tried to sort of, we have both a kind of what I call an inward facing role and an outward facing role. So an inward facing role is if you want to get your rights back from your publisher, you know, we have a kind of rights reversion kit and a guide. We have a guide to open access publishing. We have a guide to fair use for nonfiction authors. We have a bunch of guides that basically try to sort of address, and one on book publishing, what kinds of things can you negotiate for and what kinds of things are going to be harder to negotiate for. And then we have a public advocacy part, which is like the brief that we filed in the Authors Guild v. Google case, basically saying our authors want our work to be found. So the Authors Guild basically doesn't speak for all authors. So I think that it's kind of important to realize that, you know, collectively, kind of academic scholars are authors, and their interests are not well represented by somebody like Mary Rassenberger, who's the head of the Authors Guild. And so how do we make our voices heard? That's actually something which, you know, Authors Alliance at least an effort to kind of offer some thoughts in that direction.
So this is not really about media segmentation, but it is actually sort of interesting as I was listening to everybody talk about how, you know, access to different kinds of works is pretty radically different, even if you want to do the same stuff with it, right? So one of the challenges with scientific information is that by and large, there's a very small number of publishers of that academic work that control all the copyrights in it. That doesn't have to be so. It could be that since the academics do all the work to create those, like it could be the case that our libraries could actually be the repository for that and be the publishers of it, and it would actually enable lots of access. That wouldn't help with the books that are published, you know, from 1925 that you want access to, and it wouldn't help necessarily with the proprietary data that Katie wants to get a hold of. But like there's a lot of variation in terms of what people want access to and what the solutions might be there. No. Okay.
Don't know that I have a cogent response to that, but I think it raises really interesting questions about, you know, my brain's jumping to digital preservation, going back to the library and information science side of my brain, just where are materials housed? What does access to them look like? Which, you know, connects a lot of different threads that have surfaced in the conversation. What are restrictions on those access that might be coming from, in addition to copyright and intellectual property? I'm thinking about donor agreements for archival materials that might shape who actually can go in and see the materials, but also how they can be distributed and shared in a digital space. So a lot of just kind of layers of questions thinking about, you know, what are maybe best practices in the field of library and information science for preserving information and providing access, but other structures or interests that start to come in and shape the landscape. There are interesting connections, Elliott, as you were kind of making your comments, as well as Mark, what you're saying about, you know, there are different models for scholarly communication. I think we're starting to see maybe not necessarily, you know, the impact factors and tenure and promotion standards change, although things are moving. Libraries are renegotiating the big deal. You know, they're having different kinds of conversations about how institutional resources are going to these publishers. And Monica and others on this call can say more about that, but I think we're starting to see a shifting landscape in institutions wanting to renegotiate the balance of power around access to scholarly information.
Trying to see if I could find it quickly, but Tony Reese has a really good piece that's a few years old now that's about sort of private archives and what the rules are around those and how it intersects with copyright, which maybe if I can find before we're done.
So
Katie,
let me just interrupt on excuse me, about digital preservation. I didn't mention that there was a separate lawsuit that the Authors Guild brought against HathiTrust and against the libraries that had made their works available. So Michigan and Cal and a number of other state universities that have participated in the Google Books project as libraries lending their books to be scanned. One of the purposes that the universities had was to have preservation. Actually of the books in their library. And of course, given that we're in a pandemic, it turns out that since you can't get access to the physical library when it's closed, How to Trust has basically developed a program to allow people to read the copies of books that it has in its collection that are relevant to faculty or student research projects. And the courts basically said, look, if you're making a copy in order to preserve it, that's actually something again that doesn't. It's a different purpose than the original, and there's actually some preservation of work provisions in section 108 of the copyright statute. But the courts are basically pretty, again, it's not going to substitute for buying a separate book. So that's actually pretty important, that How to Trust is really kind of leading the way in making the 17 million volumes in its collection available for research use these days. And if we didn't have that How to Trust corpus, a lot of us wouldn't be able to do research these days.
I found something. It's not the one I thought of, but yeah, no, that was very much true this year. I remember Pam, we had kids home from college and they were trying to do research papers, and several of them were trying to get access to things that they just couldn't. Right? And even some of the museums were closed, and none of those things were digitized, or well, not enough of the things were digitized for them to get access to what they were interested in. Elliott, were you going to say something? You unmuted yourself. Yeah.
You know, on this whole sort of the publisher's world angle, one of the things that I worry about, and this will not be a big surprise, I think probably most people worry about this, has to do with the hyper consolidation of the publishing industry. I mean, fiction is a notorious example of this, but the concentration of the organs of opinion and the organs of creative output in an increasingly smaller number of IP holding / media companies is really concerning, not only for the small presses, which are often sort of the tools of discovery and where the most risk-taking creativity takes place, but also just in general in terms of consolidation of the leverage that those companies have. So however we can get to the model, Pam, that you were describing affirmatively as that kind of culture hub that would take notice of copyright appropriately, but also bring in the smaller publishers, I think would be intellectually beneficial for writers, authors, scholars, you name it. File under not a surprising statement by an English professor, but
So we only have a few more minutes, but I guess what I was hoping maybe we'd do at the end here is to get each of you to sort of reflect a little bit on, if you're thinking about how these issues have evolved over the last few years, what is the most hopeful development that's happened, and what's the thing that you most wish would be fixed? Not everybody at once, though.
Well, I'll go first. What makes me hopeful? Authors Guild v. Google. What needs to be fixed? The Copyright Office needs to grant the exemption for TDM.
Almost like you gave a talk on that. Yeah.
All right, well, I'll jump in, and I think what makes me hopeful is the expansiveness with which digital humanities scholarship is pursuing important questions, and the methods in many different kinds of methods that are making transparent and exciting the connections, the networks, and the ways in which knowledge has been historically produced and will continue to be produced in the present. So I'm really excited about that aspect. What needs to be fixed, I would say, is sort of public skepticism about the value of the humanities writ large, which has consequences for those of us in not just the humanities, but in law and public policy and so on. But anyways, that's what I got.
Probably can't fix that with a copyright amendment. But.
I'll attempt to have some cogent thoughts here. I think, things that have shifted over recent years in this area, and I'm particularly thinking about digital humanities and digital scholarship, like Pam has mentioned, there are more people who are doing this work. There are examples of what this scholarship can look like. We're starting to see kind of the bar move in terms of what scholarly knowledge production can look like. And as Elliott mentioned, I'm just really grateful that there's a robust research community in this area that is showing the vitality of these questions and these methods, and in some cases, the necessity of asking questions that new methods unlock answers for. So I'm really excited for the way that digital humanities has framed a conversation that is absolutely about scholarly research, but is also about collaborating across units and across institutions. So that's actually maybe kind of shifting to what are areas for continued improvement. This is maybe more thinking about local institutional contexts. You know, I'm thinking about greater transparency in what scholarly knowledge production expectations look like as we think of the wide range of disciplines that fall within digital humanities. You know, if you're in English versus if you're in American Studies versus if you're a library faculty member, those expectations of what scholarly activity look like are pretty different. And, you know, my heart is very much with graduate students who are existing in these very interdisciplinary spaces. And, you know, if you're in a history PhD program, but you're interested in digital history and you're connecting with data science, just that world of, you know, what does your dissertation need to be? And then as a junior faculty member or a professional existing in other spaces, what's the bar for how you're being evaluated is something that I think we can continue to improve on, both particularly in local institutional contexts.
Go ahead, Natalie.
To kind of jump off from where Katie left, what I'd like to add is that I think what discourages me are crisis narratives that sell us a sort of myth of constructed scarcity. I posted a link in the chat to a recent talk by Cory Doctorow, where he talks about how it's not just publishing that's consolidating, but that the consolidation of glass bottle manufacturers is part of the reason why we don't have an ease of distributing the vaccine here in the US. And that what makes me hopeful is that our crisis response in real time often counters that myth of scarcity, that together when we do form collaboratories, our responses can be prompt and effective and allow us to go places we haven't gone before. I think the CORD-19 data set was an example of that, where publishers said for this topic, for this time, it will be open access. You can do all the text mining you want to against it. That's an example to me of what the future could look like for digital humanities scholarship written with a broad brush. And the other thing that makes me hopeful is software as a first-class scholarly output. I think it's here. I think we're ready to cite it. I think we're ready to celebrate it in tenure and promotion, and I'm thrilled about that.
Lots of clapping there. So yeah, I'll only just add one thing to be hopeful about, which is that much of Pam's really terrific prior work had sort of mapped the way that fair use tends to follow patterns, and it follows patterns of practice, and especially within communities. And as these communities sort of reshape themselves, taking into account everything that Katie and Elliott said about the difficulties of that, I think it's pretty likely copyright will follow, right? It will follow it, and and wind up recognizing the sort of legitimate uses. This is already it's already doing in some respects, and I think we'll continue to do that. And I think so, which is sort of a call to say like that it's really the scholarly communities that need to sort of drive this and be the focus. So, okay, so that was a great 2 hours. Thanks to Felicia and Monica and the folks at the ND Studios and the Center for Digital Scholarship for putting this together. Thanks to all of you guys on the roundtable, and special thanks to you, Pam, for coming to do this. This was a really great talk and lots of interesting things for everybody to take home. So thanks to everybody, and hopefully we'll see you next time.